so proudly we hailed at the twilight's last gleaming, whose broad stripes and bright stars through the perilous fight o'er the ramparts we watched were so gallantly streaming, and the rockets' red glare, the bombs bursting in air, gave proof through the night that our flag was still there. Oh, say does that star-spangled banner yet wave o'er the land of the free and the home of the brave?
I have seen this gentleman talk before, and I found it very interesting what he had to say. It's on estate planning. It's something, a subject that we all tend to sometimes put off on the side and think everything's okay. He's going to show us some ins and outs of estate planning. His name is Micheal Nahas. He's an attorney. He's been 30-plus years in the law practice, of which 20 of that has been concentrated on estate planning. So I think you'll find his presentation very interesting. You may want to rethink some of what you have as far as wills or a trust or whatever. So with that, I'm going to let him go because we're getting a little short on time. Micheal Nahas.
Thank you, gentlemen. Very happy and proud that you asked me out to come and speak with you guys today. A little bit of homework first. If you have a cell phone, if you can put it on stun or vibrate, very simply, I have this whole thing memorized, and if it goes off, we're going to be here all day because I'm going to have to start over again. So, and if you have questions, we're going to hold those to the end. We're going to have a little Q&A session because, again, if you get me off track, I don't want to have to come back and start over and keep you here past lunch because Eaton Park sounds good right about now. Now, I'm going to have, some of you have some of the yellow forms. If you don't, Phil back here is one of my financial advisors. He has these yellow forms. I need to have you guys fill those out for administrative purposes, and it helps us keep track of who we've talked to and who's coming in to see us, so I can make sure I have your address and things like that. So anyway, a little bit of help. About me personally, I am a graduate of North Allegheny High School. I was telling Mark, I actually used to belong to this Swickley back in the late 70s because we lived in Franklin Park. And as you know, Franklin Park uses Swickley's mailing address, so we used to come down here all the time. I went to the University of Pittsburgh. Glad to see that Pitt's going to show up for some things, because until last year, they didn't show up for football games for a long time, huh? I have my law degree. I went down to DC for law school, and then I was 4 credits away from graduating, and I got the phone call one day. And that phone call was from my dad. I pick up the phone and go, "Hey, Dad." And he goes, "How'd you know it was me?" I said, "Oh, I have this thing called caller ID." He goes, "Well, it's like voodoo." I'm like, but he said, "I need you to come home and help me out." I said, "Sure, I come home on Thursday. What do you need?" He goes, "No, I need you to move home and help me out." I said, "I'm 4 credits from graduating law school. What are you talking about?" He goes, "I want to open up a restaurant." "I'm 4 credits from graduating law school." I said, "Yes, I know. I'm helping pay for it. But you're the only one I can trust, and you've worked in restaurants since you were 15. I'm like, oh. So I worked it out where I could do a 4-credit class, or 2 credits with Duquesne, and do a 2-credit externship with the Superior Court again because they liked me and said I could come back anytime. So I finished my 4 credits. I ended up working with the Allegheny County and did that for the first 10 years of my career. And the first 9 or so I was in trial work. Enjoyed that to the point, but you get kind of numb doing the same thing all the time. And after a while with some of the legal stuff, you were like, you know, do I really even need to stand here? Everybody knows what I'm going to say next. So I went into management, thinking that would be a good change of pace and a break. And let me tell you, that was a bad idea. If you ever thought of like what it would be like to manage 60 attorneys, what was I thinking? So I ended up leaving. I was the deputy director for the largest law department we had. I've been married for 28 years to the lovely Mrs. Nahas, and I will refer to her as that all day long. She is my office manager. She's my partner in life, and she runs the office. So on those yellow sheets, when you get them, that last part's very important because it rates how I did in my talk. And if you'll notice, I gave you a scale to rate me from 10 to 10. You pick whichever 10 I get, because she says based on how you rate me is if I get a raise or not. So the real reason I like doing these seminars is I have two daughters, 27 and 24, still living in my house with one bathroom. I'm trying to move them along, gentlemen, so if you have a man in that age group, see me afterwards. I am not opposed to arranged marriages at this point. Okay, what to expect and learn about today. Number one, you have to understand there are 3 ways that you can die. And you're all going, I can think of 10 off the top of my head. What are you talking about? Legally speaking, you're falling into one of 3 categories. So I want you to understand what those categories are, what the common mistakes and misconceptions each of them are, and I want you to understand a little bit of the dangers of long-term care and probate. So, the most important thing though is I'm going to give you information so you can start figuring out what's the best solution for you. Because see, that's really what it comes down to. You can't have a cookie cutter thing and say this is going to cover everybody. But yet, what do we all normally do when it comes time to thinking about this? Well, I got to do a will. How do you know that's your best choice? Because see, when you pass, the 3 ways are you can have nothing, you can have a will, or you can have a trust. And in a group this size, I usually have a little bit of all 3. Who are my procrastinators that have nothing in place and are never going to die? Anybody? Couple? Okay. Who are my will people? Anybody have a will? Okay. Keep your hand up if you've updated your will in the last 5 years. Really? You guys are good. That's a high percentage. Okay. And where are my trust guys? Couple trust people. Okay. Now, that's the 3 categories we're going to fall into. So what I want to do is walk you through all 3 choices so you can see the results and give you an idea, start thinking of what's best for your family. Because when we do estate planning, we're not necessarily doing it for us because we're dead. We're doing it for those that we leave behind to make their life easier. So, if we do nothing, what are the choices? 70% of us choose to do nothing. Now, in here, that didn't seem to be the number, but see, we're all of that certain age where we start thinking about something might happen. You got to remember, there's 18 to 45-year-olds that are still making the same dumb decisions we made. The only difference between us and them is we lived through the dumb decision. Some of them aren't going to make it, and they have nothing in place. So, 90% don't know what's going to happen with their stuff. Who's going to take care of my minor children? Who's going to make health care and financial decisions if I can't? So let's look at Bill and Mary. Bill and Mary are my typical couple. They're our example couple. Doesn't your wife sit next to you, put her arm around you, and look at you like that when you're watching TV? Lovely Mrs. Nahas does it. She sits over in her chair and does, don't touch me. All right, they've been married for 38 years. 2 kids, John and Susan. John's a little lackadaisical. Susan's kind of the more responsible one. They have an average estate for Western Pennsylvania, about $500,000. Means they have some money in the market. It used to be a lot more. A couple months ago, it took a dip, like a lot of ours. They have a house, and they have a car or 2. $500,000, you're not the Rockefellers, you're about average. They choose to do nothing. What's going to happen with their estate? Well, statistically speaking, who's going to pass first? Bill. Who's in charge when Bill passes? Mary, if Mary's name's on all the accounts and investments. if her name's not on the account, she doesn't get immediate access just because they're married. I had a family in Greensburg, the husband owned a piece of property, he died, the wife had to go through the probate process just to get access to it. And then she gave it to her son. So, but Mary typically is going to be in charge. That's not the big issue. The problem comes when Mary passes. When Mary passes, who's in charge? John, Susan, somebody else? Well, we don't know. Why? Because she doesn't pick. So what's going to happen is the court's going to have to say to the kids, do one of you, both of you want to be in charge? And of course, if they can't agree on who should be in charge, then they're going to have to go into court and the court's going to have to decide. If they don't, nobody wants to be in charge, again, the court's going to decide. So see, the problem is, if you're procrastinating, you don't think you have an estate plan. And you really do. It's just going to be given to you by the Commonwealth of Pennsylvania. Now, if you think the Commonwealth of Pennsylvania does anything efficiently and fast, you'll be happy with their plan. If you don't, you need to opt out. You need to do something to get out of the state-given estate plan. And again, 70% of the people choose this. Okay, some examples of people you would think that have access to good information but didn't act on it. John Denver lost $19 million for doing some bad estate planning. James Brown Prince died in 2016. Who remembers when Prince died almost every night on the nightly news, well, there's a brother or sister that have come forward. Why? He had nothing in place. And if I could prove I'm a blood relative, I might be entitled to something. James Brown died in 2006. Cost his family a lot of time and money to get everything settled. Who remembers Chief Justice Earl Warren? He handwrote his own will, screwed that up. Just because you're Chief Justice doesn't mean you do this type of law. And see, that's the thing about doctors and lawyers. Everybody wants to make jokes about the medical profession, but at least they tell you what their specialty is. Why? They have those initials at the back of their names. And you know you're not going to the proctologist about your brain tumor. If you are, you got a problem. I remember when I was going to get my first colonoscopy, my wife said, hey, can you have the doctor call me when you get there? I said, why? She goes, I want medical proof that your head ain't up there. Lovely Mrs. Nahas is a funny woman, let me tell you. All right, option 2 is having a will. Now, I will say that having a will is better than nothing. Why? What's the purpose of the will? It tells the court who you want to be the administrator or executor and whom you want to be the beneficiaries. So it's a little bit better than having a will. But the big misconception is your will is still going through probate. And that's the problem. Anybody been through the probate process as an executor? Okay, a couple of folks. I'm going to designate you guys to be the representatives of the class. As I talk about probate, if I say anything that's wrong, you let me know. And you tell them, hey, no, that's not the way it happens. Fair enough? And I don't know any of you guys, so if you don't call me out, you guys can all assume I'm talking the truth. But what's the problem with probate? Well, the first one's the high and unknown cost. What do you mean high and unknown cost? Most attorneys, when they get the phone call to probate an estate, they're going to charge a fee. That fee is normally based on the amount of the estate, the gross value, not the net. And we don't know what your gross value of your estate's going to be when you die. Somebody in here may have hit that Powerball. Somebody could go to the rivers and lose it all. So we don't know. I can tell you what it would roughly cost you to probate your estate today, but see, when you're gone, we don't know what the actual numbers are going to be until you're gone. Potential delays. Probate's a public and open forum. Anybody can get information, and they can use that information for numerous types of things. Anybody ever heard of a dead person having their identity stolen? Where do you think they get the information? A lot of it comes from the Register of Wills office, because it is all public. If you have to have a court-ordered guardian, same type of thing. So here's the probate process. We're going to start off with your stuff. That's a legal term. I spent a lot of money to learn that in law school. Your stuff is what we need to take care of. You have a will who appoints an executor. That executor then goes to the court. They get sworn in. They have to fill out paperwork just to get sworn in. They have to pay fees just to get sworn in. You're also going to definitely have attorney fees. You may have accounting fees. You may have court, you're definitely going to have court fees, appraisal costs. And if you don't write your will properly, you may have to have them get bonded, which is another nightmare. So, once everything is done and paid, and the taxes are paid, and the bills are paid, the heirs get what's left over based on what I tell them they should get. So a will is a little bit better because I'm telling the court who I want to administer everything. That makes sense? Okay. Why do we have probate, though, with a will? Well, when I die, my wife and I have a house. We did a closing. We went and signed our name to buy this house more times than you'd think you'd ever sign your name. Anybody remember your closing? I was still a young lawyer back then, and we went to the closing. The first couple pages, I'm reading them because, you know, I got to show these people I'm a lawyer. I know what I'm doing. About the fifth or sixth page, I'm like, just signing. We get done. We walk out. She says, "Did you read all those papers?" I said, "No." She said, "You're a lawyer, for God's sakes." I said, "That's what I paid that lawyer in there for. He's supposed to read them." So I'm sticking to that story. But see, when you have titled assets, whose name is on my deed? Mine and my wife's. When we die, whose name is still on our deed? Mine and my wife's. When I do a will, does that will transfer the ownership to anybody? No. So even though I appoint my daughter as my executor, and I say sell the house and split the money with your sister, can she legally sell what she doesn't own or control? No. So she has to go to probate to get appointed by the court to be able to sign for me. Then she can call the realtor, sign the listing agreement, sign the sales agreement, go to the closing and sign over the deed. Same thing with a car and a bank account. Those are all titled assets. So when we die, we leave those things behind with our name on them. Probate just allows somebody to sign for the dead person. Does that make sense now? Okay. So the average cost for the attorney fee is going to be between 5 and 10%. Doesn't sound bad till you think about it. Because those, personal injury guys are taking 25 to 40%. Guys in probate, we're only doing 5 to 10. That doesn't sound bad at all. Plus you have it's contestable. People can come back and claim that they were owed money up to a year afterwards. And here's where someone having the public forum isn't good. People will go to the Register of Wills, get the information, what's in the estate, the amount of the estate, who the executor is, and they'll send a phony bill. And they'll send it for something small that you can't really check. Like, hey, we cleaned your dad's furnace, we're sorry he died, but it was $400, we're still owed $300. How do you check a furnace was cleaned? They don't make it too high and they don't make it something big because you send out 20 or 30 letters, you make it up in volume. If they just send out a letter when my dad died and said, hey, we replaced his roof, we're still owed $9 grand, I could have driven by the house and said, wait a minute, those are the same hill marks I made when I was sneaking out. They didn't do anything, I'm not paying that bill. Because I could readily check on that. So, you need to understand all the pitfalls. All right, so probate, high and unknown costs. 5 to 10% on an average, which like I said doesn't sound bad till you do the math. When you look at Bill and Mary's estate, that means that probate attorney's charging $25,000 to $50,000. Can you see why they want the phone call now? Who do most people call when mom and dad die? When they have a will, they call the lawyer. Who wrote the will usually, because they think, oh, that's who mom and dad use, that must be who we're supposed to call. Oh, sorry for your loss, come on in, we'll help you probate the estate. It's the loss leader, that's why they don't charge a lot to do the will. Okay, Pennsylvania inheritance tax, you're still dealing with that. And in Pennsylvania, don't let anybody tell you a trust will change the inheritance tax, it doesn't. We tax the relationship of who you give the asset to, not the amount of the asset or not the type of asset. So kids and grandkids paying a 4.5% tax. Brothers and sisters pay 12. Nieces, nephews, and non-relatives pay 15. Same asset, different tax rate on who you leave it to. I do not like that because it punishes people who didn't have kids, couldn't have kids, or tragically lost their kids. Okay, this is what's called the Johnson probate chart. This is a court-driven document on what they say a reasonable attorney should charge to settle a reasonable estate. A couple of things. Number one, if you notice, the smaller the estate, the what? Bigger the percentage. Now, secondly, if you're probating anything under $1,750, don't do that. Because a lawyer's going to charge you that to probate something that you're not going to see anything of. Where do you think most people fall into? Right here. And what do you think has the highest minimum rates? That one. Why? Most people fall into it. We're going to let the attorneys maximize their profitability. Okay, potential delays. Generally, it's going to take 6 to 24 months to get everything settled. If anybody wants to contest something, that's just going to go up in time frame. The more time it takes, the more expensive it's going to be. I have to tell you, I did an estate for a couple that I did their estate plan for. I told them, people are going to fight and argue. Oh no, my kids never fight. They get along really, really well. Okay. 3.5 years later, we're done arguing about the estate because 2 of the kids were mad they weren't the executor. And they went through 4 different lawyers trying to get her just taken out as the executor and have one of them appointed. Where do you think most of their inheritance went? To the 4 lawyers until they found somebody that would do what they wanted to do. So, because Allegheny County, we have the 2nd highest senior population in the nation, next to Dade County, Florida. We also have #1 per capita for golf courses, so we're all good with that. But the whole idea is we have a lot more people who pass away. There are a lot more people going through probate, so that tends to slow everything down from, say, Bucks County. The public information we talked about. Little thing on nursing home care. AARP says 70% of the people that reach 65 will need some type of assisted care. People that go to a senior center, 40% of them will not go home. It's something you need to think about. The other thing is, a will doesn't help in that case, because the will doesn't take effect until you're dead. So you need to have things in place like powers of attorneys, living wills, healthcare power of attorney, for those times when you're incapacitated, because here's the problem. You become sick, you're incapacitated, they need somebody to make a healthcare decision. If you didn't appoint somebody, somebody's going to make the decision, and it might not be the person you want, and they may make a decision you don't want. And unlike golf, you don't get a mulligan if they make the wrong decision. So, all right. When the estate recovery program, if you go to a nursing home, you need to understand they're going to take the assets and you have to spend everything down to about $3,000 before Medicaid will start paying for everything. Now, I use this to talk a little bit about the efficiency of the Commonwealth of Pennsylvania. Who remembers the Affordable Care Act? Well, Pennsylvania decided they wanted the extra money from the federal government. So they said, we would like to take the money from the Affordable Care Act. The Affordable Care Act people said, great, you just have to go after the money and recover it more aggressively than you are. Now, in other states, do you know what they did? They called all their recovery teams together and said, be more aggressive, go after the money more. You know, in Pennsylvania, what we did? We started a whole new bureaucracy and put it under the Department of Human Services and called it the Enhanced Recovery Department. Doesn't that sound efficient? Well, here was my problem. In 2016, I got a letter. First of all, they got my address wrong, but the post office still found me. And it says, hey, Mr. Nahas, your client died. We'd like information on where his assets were. Do you think they included a signed release from my client that he signed while he was at the nursing home? No. Don't have a release from my client. I called the executor. I said, do you want me to release this information? What do you think they said? No. This caused me quite a conundrum. Why? Because what happened was there's a little thing called attorney-client privilege. It's one of the canons of ethics. If you violate it, you could be suspended or disbarred. Either of those things would make the lovely Mrs. Nahas not very happy. So my problem here is, on the one hand, here's the state telling me, we want the information of your client's assets. On the other hand, here's the state telling me, don't give up any information without a release or we'll disbar you. So I wrote them back a nicely worded letter explaining my conundrum and said, can you contact the state disciplinary board and ask them for an advisory opinion so I know what to do. Why? Because if they said release the information and my client takes me in front of the disciplinary board, I wanted to hold up their letter and say, you told me to give them the information. If on the other hand they said don't give them the information, I wanted to be able to hold up the letter if they take me for some type of obstruction and say, they told me not to give them the letter, the information. 2016, who wants to know how long it took me to get a response?
Did you get one?
Still waiting. So if I get one, let me know. I'll keep you in the loop. Which brings us to the guardianship idea I mentioned. Guardianship affects me while I'm still alive. So if there's a car accident, Bill becomes incapacitated, who's going to be his guardian? Mary. Car accident, Bill dies, Mary's in a coma, who's going to be in charge, John or Susan? Again, we don't know, because they didn't pick. So, the court's going to have to decide, and who's going to pay the bills, who's going to make medical decisions. The court might not like either of the kids. So they're going to pick a third person, they call guardian ad litem, and appoint them, and they're going to charge the estate on an ongoing basis until Mary passes. All right, so option one is do nothing. Option two, have a will. Option three, is there a better solution for most people? Yes. I think most people are better off having a trust. Why? It avoids probate if it's properly executed. Main types of trust are revocable and irrevocable. I'll explain the differences. Most people do a revocable trust. How does a revocable trust avoid probate? Well, very simply, we give the assets to the trust, and the trust now owns the assets. Who are my Susie Orman fans? Nobody? Susie Orman says everybody in the free world, including communist China, should have a trust. I don't go that far. If you live above somebody's garage in a one-bedroom apartment and have a bank account, we can show you how to avoid probate. The problem is you have to share all the information. Here's why. If you came to me and said, Mike, I live in a studio apartment above my neighbor's garage, I've got $15,000 in the bank account. Do you really need to worry about probate? No, we'll do a will, we'll show you how to avoid probate with the bank account, you'll be fine. The problem is you didn't tell me about your $500,000 annuity or IRA. Why? Because you're thinking about, well, that doesn't go through probate because there's a death benefit on there. That's correct. But unfortunately, we live in Pennsylvania. In Pennsylvania, your IRA or your annuity is inheritance taxable to your beneficiaries if you're over 59 and a half when you die. So now your estate is how much? $515,000. And the attorney's going to take the percentage of what? The gross value of the estate. You need to make sure that legal and financial work together. That's why I actually have one of my financial advisors, his name's Phil Becker. He's sitting here with me and he'll help give out some information later. But you need to understand, if you have a financial advisor, we want to work with them because legal and financial need to work together. Okay. So let's see what happens when Bill and Mary have a trust. They have a house, their vehicles, CDs, stocks, bonds, checking and savings account. They have their trust. Until you fund it, your trust is what's called unfunded, which means it's empty. It doesn't own anything yet. How do we get the trust to own things? Well, with real estate, we have to draw up a new deed. We file that deed at the Recorder of Deeds office, and my deed, because I did a revocable trust for myself and the lovely Nahas, my deed went from Micheal and Tristan Nahas to the Micheal and Tristan Nahas Revocable Living Trust. So now, legally, who owns my house? The trust. My trust says when my wife and I are both deceased, my oldest daughter is our successor trustee, which means she has authorization to sign for anything that's owed by the trust. When we die, does she need to go to probate? No, because the trust is still living. She's already authorized to sign. She needs a death certificate for my wife and I. She can call a realtor and she can sell the house tomorrow after we're dead. Does that make sense? It saves a lot of time and money, and now that $25,000 to $50,000 that was going to an attorney, where's that going now? To the kids, where I thought it was going to go in the first place. And see, this is a good way for folks to be able to take care of charities and organizations in your church or your food bank without taking money from the kids. Take it from the attorney. You could give the food bank $10,000, the kids are still coming out ahead. Fair enough? So you need to fund the trust. You put the items that are titled into the name of the trust. When you pass, the successor trustee can control them and give them out where you want them to go. I can still say, I want my house to go to my 2 kids, or I want the house to go to this person. I want you to split the money from the sale of the house. I can still control that. But if you don't fund your trust, it's not going to do what it's supposed to do. Okay. So Bill and Mary do a trust, they get it funded. Who's in charge while they're alive? Them. Bill passes, who's in charge? Mary. She passes, they have Susan as the successor trustee, so Susan gets all the assets together, sells what needs to be sold, liquidates what needs to be liquidated, and splits the money with her brother, and everything goes 50-50. No attorney fees, no court fees, as long as everything's properly funded. So it avoids probate, has a lower cost and higher value overall, no delays, it's not public. Power of attorneys and living wills and all that stuff should be included with a properly done estate plan. So, with a trust, in a will, is there probate with a will? Yes. Probate with a trust? No. Private delays with a will? Yes. Delays with a trust? No. Privacy concerns with a will? Yes. With a trust? No. Institutional care help with a will alone? No. With properly done estate plan? Yes. Same thing with guardianship. The big one is the cost. We know the will is going to cost at least $25,000 to $50,000. What should a trust cost? Well, I know there's a guy in Butler does them for $10,000, which is still less than $25,000 to $50,000, so that should still be a good bargain. On average, though, you're going to pay somewhere between $5,000 and $8,000. However, my office, we do the plan for $3,500. So, the 3 options for most people, a trust is going to be the better option. The revocable trust helps avoid probate. Now, I mentioned the irrevocable trust before. That is if you want to avoid the nursing home taking the house. How do you do that? You put the house in the name of the trust, but you can't be the trustee. So in my case, I would put my house in the trust. My daughter would be my trustee while I'm still living, so technically she controls the house. The trust makes it for my benefit, but she would be in control. As long as I stay out of the nursing home for 5 years after doing the trust, when I go to the nursing home, they say, Mr. Nahas, what do you own? What do I legally say? Nothing. And some people want to get that 5-year clock ticking, so they'll do what's called a hybrid trust. They'll do a revocable trust for the things they want to maintain control of, and they'll do an irrevocable trust for the real estate. So, consultation. I'm going to give you guys an opportunity to schedule time to come in. Well, actually, I'll come and talk with you. With the pandemic, we actually found that people like having us come out and meet with them in their home. It's a little bit more convenient for them, especially with the price of gas now, too. But we'll schedule time, sit down with you wherever you want, or you can come to our office, sit down, talk with us, and give you a free hour to figure out what's the best solution for you. So, single people are great to come in. Why? Because you don't have anybody to talk to, you don't have a spouse to bounce ideas off of, and you don't have anybody giving you other thoughts. Married people, it's good to come in and talk with us. Why? Because you have a spouse, somebody to bounce ideas off of, somebody to give you ideas, and you may not agree. So we can kind of help walk through that minefield. Blended families, especially. Why? Because blended families tend to have his, hers, and ours. We sometimes want his to go to his, hers to go to hers, and ours to kind of figure that out. Families with special needs. If you've got a beneficiary that's on SSI, you definitely want to figure out how to get them the assets without getting them kicked off of disability. And if you have a trust or a will that hasn't been reviewed in 5 years, you want to come in and talk with us. So, now, I will make appointments with you today, and normally I'll call you 24 to 48 hours before the appointment and confirm. Occasionally I'll get somebody that calls me and says, Mike, I have an appointment, but I'm going to cancel that appointment. Why? Well, I talked to my financial advisor and he says I don't need a trust. He took care of all my assets and they're not going through probate. That is correct. Your 401, your IRA, your annuity is not going through probate. First thing you need to ask your financial advisor is, why are you practicing law without a license? Because that's legal advice, that's not financial advice. The second thing is you say, hey, what are you going to do to keep my house from going through probate? And their response should be, nothing, because they're not a lawyer. They can't do a deed. So, that's one of the things that people think about. Well, why don't you give your house to your kids? Sounds like a good idea. Except when your child passes and they leave everything to their spouse, and you get an eviction notice from your daughter-in-law or your son-in-law saying, hey, we're selling the house. And it sounds funny, and that wouldn't happen to me, but I got a phone call from an 82-year-old lady last year, and it's exactly what happened. She left her house, gave her house to her son, he died, and the daughter-in-law is selling the house. Where's an 82-year-old lady going to go get a mortgage to buy her own house? Remember, legal and moral don't necessarily go together. So, legal and financial have to work together. This one, I tell you, my lovely Mrs. Nahas and I have a little disagreement. We agree to disagree. If you call me and say, Mike, I'm canceling my appointment, I'm going to say, because I talked to somebody, who'd you talk to? I talked to my lawyer. They said I don't need a trust, or I don't need to talk to you about this. They have it all handled. Yeah, they wrote me a will, I'm good. Before you call me and cancel your appointment, here's what I want you to do. I want you to say to the lawyer, hey, thank you so much. I appreciate that. I'll be down in an hour. What do you mean you'll be down in an hour? I'm going to pick up a letter you're going to sign and notarize saying you're going to probate my estate for what this guy would charge me to do a trust and keep from going through probate. And if they won't give you the letter, what should that tell you? Maybe I ought to keep that appointment. Now, this one I tend to understand is the kids. Dad, I looked it up online and I can get you a will on LegalZoom for $69.95. Don't confuse your Google search with my law degree. Not everything on Google is going to be actually the best way to do things. Because Google only answers things that you ask. It doesn't tell you the downsides on the things that you don't know about. For example, if I give my house to my son now, he outlives me, but he goes to sell the house, does he pay inheritance tax? Nope, because I gave it to him. He had it before I died. Does he pay any probate fees? Nope, because he owned the house before I died. Sounds good so far, right? In my case, I bought my house in Stanton Heights for $60,000 in 1993. Right now, it's probably worth about $300,000. That's $240,000 of equity. If I give my house to my daughter now, what's her basis in my house? $60,000, what I paid for it. She sells the house. No probate, no capital gain, or no inheritance tax, but she now has to pay capital gains tax, which is a lot worse than paying the inheritance and the probate fees. So you need to know what the downsides are, not the way to avoid something that you think is necessarily bad. Because probate and inheritance tax isn't as bad as the capital gains tax. So bring the kids into the process with us. And whenever you're comfortable, I love talking to the kids. I did an appointment with a client yesterday in our Cranberry office. She brought her daughter with her. Daughter left and said, "This sounds like a great idea. I got to talk to my husband about us doing this." So, all right, so to avoid procrastination, we're going to give you an incentive, because I know some people say, "I've been thinking about doing something for years, but I just haven't done it." Well, I used to be a procrastinator until I married her. And the lovely Mrs. Nahas used to get mad at me because I said, "I'm going to procrastinate one of these days as soon as I get around to it." She is not a procrastinator. She says, procrastination is not a success principle. You could wake up my daughters in their sleep, start that quote, and they would finish it for you. So we're going to give you an incentive. Normally, when we do a trust, it's $500 for the consultation. We're going to do that for free. Normally, the trust package itself is $4,000. So you're talking about total $4,500. I already told you we're going to give you a discount. If you're married, it's going to be $3,500. If you're single, we're going to do it for $3,300. Why? Because it's less work. We have to do less power. We don't do 2 powers of attorneys. We don't do 2 financial power of attorneys. We don't do 2 living wills. So less work equals less fee. Don't go home and kill your spouse so you can save $200. It's not worth it. So, but it's roughly $1,500 in savings. If we book an appointment, you come in and see me, because these guys had me come in, I didn't have to market or do any advertising for you. So we pass those savings on to you. That just seems fair to me. All right? So we'll schedule an appointment. We'll follow up and have you get called 24 to 48 hours beforehand, confirm your appointment, and then we'll make sure that we show up and we get you helped. Fair enough? All right, any questions from anybody?
You said there were 2 kinds of trust.
Yes.
Could you explain the second?
Sure. The irrevocable trust, I put the properties and the assets in the name of the trust. I am not the trustee, though, so I do not control the assets. The trust is for my benefit. So my daughter would be my trustee. She would have legal control of my house. So if downside would be if I want to sell the house, she says, "No, Dad, property values are still going up. You'll leave money on the table." I technically can't make her sell the house. Downside is if property values start going down and she says, "We need to sell this before we hit rock bottom," I may not want to sell the house and move, but she's in control, and as long as she's doing it for my benefit, then she's within her right. Any other questions?
Michael.
Yes, sir.
Do you have a revocable trust? Do you need a will?
Microphone. Use your microphone.
If you have a revocable trust, do you also need a will underlying it?
That's a good question. The answer is, do you need one? No, but I would recommend you have one. I do one, and we call it what's called a pour-over will. And what it does is it says, if there's something that has to go through probate, which would happen how? I do the trust for you. We help you fund it. I put the house and the real estate in the trust. Phil would help you put the bank accounts and any other financial accounts that need to go into the trust. But we like to have our clients do a review every year or 2. If during that time you're walking down the street and you see PNC is giving away free flat screens for a $2,500 money market account, you go in and open up that money market account to get the flat screen TV, you put it in your personal name. You die before your review. Where's that account got to go? Probate. So we want to make sure there's a valid will that says, "Hey, Judge, I did a trust. For some reason, there's an asset not in the trust, but look to the trust to see who the beneficiaries are." But I want to spend time educating you so that doesn't happen. So that's one of the reasons I don't charge for phone calls. Because when you're sitting at the bank and you're going, I remember Mike saying there's something I got to do with new assets to keep them from going through probate. I want you to call me. And for a 2-minute phone call, we can solve that issue from becoming a big issue down the road. And I'll just tell you, hey, make sure you have them put it in the name of your trust. In fact, let me talk to the branch manager and we'll help you get that taken care of. Does that make sense?
Yes, sir.
Hold on a second. Use the mic. Here, let's go with, the mic will be the one.
The talking stick.
Could you comment on the minimum distributions for inherited IRAs? There seems to be a lot of confusion about this.
Actually, I cannot.
Okay.
Because, now that would be a good question for Phil, because I am not a financial advisor, I'm not a financial person, I don't give you financial advice, because I think people need to stay in their lanes. And my dad always said you can only be good at a certain number of things. I'm good at doing legal stuff. When it comes to financials, I rely on the same people that you rely on, financial advisors, people that do that as their specialty. So when it comes to minimum distributions and all the other rules, I have enough problems keeping up with the changes in the law every year. Yet on top of that, their stuff changes like weekly. So I apologize, but you can talk to Phil.
Is there a minimum amount under which there is no probate?
No, depends on the type of asset. So you could have a bank account with $5 in it. The bank's not going to give up that $5 without a court order.
Okay.
Perhaps, say you've squirreled away a large amount of money in a safe in your house.
Uh-huh.
And
Okay, we're all going to Pat's house tonight.
okay, you have it with your guns, you know, and you pass, and the money is not taxable, right? Because there's no record of the money.
What money?
That's why I'm saying. I just wanted to check.
You don't tell me about it, I can't list it.
Okay.
If I don't know it's there. Anyone else?
Any other questions?
That would hold true for a safe deposit box, wouldn't it?
Safe deposit, I do not like safe deposit. They're such a pain to get into. It used to be you could just go to the bank and the person from the bank would let you in and they would record that they were there. Now, you have to write a letter to the Department of Revenue. You have to tell them where the safety deposit box is located, the address of the bank, the date and time that you're going to the bank, the people that will be with you at the bank, the people from the bank that are going to be the representatives for them. And then they'll open up the box and then you have to send them an inventory of what was in the box within a certain period of time. So, I don't like safety deposit boxes just because the administrative pain in the butt.
Well, if it's a joint safe deposit box.
If that other person's still alive, but if it's just you and your wife and you're both gone,
Well, if you're not using a safety deposit box, where would you suggest putting your money? Under the mattress?
in Pat's gun safe. No, I tell people all the time, I say, look, get yourself a little fireproof safe, keep it at your house, keep your important documents in it, and make sure whoever's supposed to be in charge knows how to access it to get those documents.
Okay. Any other questions for Mike?
Okay. Well, if anybody wants to book an appointment, if you just raise your hand, I'll come around and give you a folder and some information on how to and we'll get that scheduled for you. So.
Great, thank you, Michael, very much for coming in and educating us a little.